Ron Barrett again here, owner of Linen Tablecloth. This episode exposes the lies that UPS lawyers told before and during our trial back in September. The first whopper was UPS's attorney's attempt to limit the amount of damages UPS would be exposed to by misleading the court as to the date when we informed UPS about the overbilling we had discovered. The later UPS could claim that we notified them, the less the potential money we would be able to recover. Now, UPS filed a motion for summary judgment claiming that LTC had not submitted an overbilling claim with supporting shipping data until October of 2019. But this was a blatant lie, and UPS knew that it was. I submitted my claims 9 months before, back in February. UPS took an email I wrote in October out of context where I said, I finally finished my overbilling claim. But what they left out was that this was the third time I had submitted it. They played dumb, pretending not to know of all the previous claim submissions. Now, please understand, these lawyers are supposedly at the top of their legal profession. They're paid more than $800 an hour. They're not lazy or stupid. By the time of their summary judgment filing, they'd been working on this case for over 2 years. So putting forth a deception like that was not an innocent mistake on their part. They lied on purpose. Example number 2. UPS didn't deliver the LTC package scan data because their systems automatically erased the data after 66 weeks. Well, this is what they told us in the court. Apparently, nobody at UPS thought to stop the automatic erasure of LTC's shipping data, even years into the lawsuit. This explanation, while hard to believe, actually confused everyone for quite a while. It wasn't until recently, months after the trial ended, that I realized that this explanation of why UPS failed to deliver LTC shipping data was a cover-up, and here's my proof. If it is true that UPS's systems automatically erase package scan data after 66 weeks, why does the shipping data given to me by UPS reps back in January of 2019 contain package scan data from the beginning of 2017? Some of it is gone, but much of it isn't. So if it automatically rolls off after 66 weeks, why do I have data that should have been automatically erased? If one looks at the data I was given, one can see that only some of it was erased. So it appears that the erased scan data was deleted intentionally because it likely told a story UPS didn't want anyone to hear. The UPS had knowingly overbilled Linen Tablecloth for package dimensions they knew were incorrect. There is no other logical explanation for why some of the package scan data is gone and some of it still exists. Intermittently erased data exists all the way through 2017, 2018, and 2019. The third big lie that UPS told was during the trial. This involves a set of data called DIAD, Delivery Information Acquisition Device data. This data is basically the travelog record of a package transit through UPS systems to its final package scan when it gets delivered. Now, UPS lead attorney Greg Colton put forth a theory in front of the jury that the reason no DIAD data exists for packages LTC claims were billed but never shipped was because the delivery driver must have failed to scan the package on the porch of the customer it was delivered to. This theory is ludicrous. It's actually stunning that he would dare to put something so easily debunked in front of a jury. DIAD devices help the driver deliver the package. In order to do that, the package needs to be scanned into the delivery truck, and then the DIAD device can act like a GPS guidance device and give turn-by-turn instructions to the driver. All of this, every step of the package journey along the way, is recorded into UPS's systems. So it is impossible for all of the DIAD data to be missing just because the driver may have failed to do the final scan of the package when it was delivered. In order to get the final scan, the package would had to have been scanned into the truck, and numerous times even before that. If the package was delivered, then where is the scan of it when it was loaded into the delivery truck? And why wasn't that scan data given to LTC, as UPS was legally required to do? This next lie is a bit wonky. It could be considered a half lie, I suppose, if Colton is right, or it's a blatant lie if Colton is wrong. Basically, Colton said that it's impossible that LTC was charged for return packages never shipped. At trial, the expert admitted on the stand that Linen Tablecloth had been charged for packages that had never shipped. Here's the court transcript. Now, to dig into it, UPS did create a specific account for Linen Tablecloth for returns only, and they never told us that by using this account, we would only be charged for packages that got scanned into UPS's systems. If they had told me that, then I would have demanded that all of our accounts become scan-based accounts. So regardless, they created this account, they told us to use it. When I asked them why, they said, oh, it's a UPS bookkeeping thing, please just use it. So, being the dutiful guy that I am, we did use it. However, we didn't use it all the time. We used it haphazardly. Sometimes my customer service reps would use it. Sometimes they would use our other accounts. So, were we charged for return shipping labels that we never used? Probably. But there in court, nobody objected because it's too complicated to explain this. He misled the jury. So UPS created this account for us, a scan-based account, and then after a year, they killed the account. And they didn't tell us that they had killed it. So all throughout 2019, we were printing return shipping labels on our old account, which was not a scan-based account. I apologize for the complexity here, but this is the type of half-truths, half-lies that Colton told. The reason was to overwhelm the jury and confuse them. And I think he actually accomplished that. Mr. Colton, there are rules in your own American Bar Association that prohibit you from acting as you have in this case. Let's read a few. Rule number 3.4. A lawyer shall not conceal a document or material having potential evidentiary value. Falsify evidence in trial, shall not assert personal knowledge of facts in the issue. Or how about rule number 4.1? Truthfulness in statements to others. A lawyer shall not knowingly make a false statement of material fact or law to a third person. You've absolutely done this, Mr. Colton.